One of the biggest fallacies amongst consumers are that you cannot reject a claim for driving under the influence of alcohol unless blood and/or a breathalyzer test were conducted. This is not the case, and many clients confuse contractual law with criminal law. Your insurance policy with your insurer is a contract. This contract stipulates that you should not drink and drive. Why? Because one thing we cannot argue about is that drinking impairs your ability and increases the risk of a vehicle accident. South Africa has a drinking culture, and considering we don't have a public transportation system as evolved as the first world countries, do a lot of people believe they have no alternative but to drink and drive. No matter your point of view and or your justifications for drinking and driving, all we can say is if you drink and drive, are you doing so on your own peril? Because this is one risk no insurance company is willing to take. Vehicle accidents involving drinking and driving are generally more severe, and you find that most vehicles are non-drivable or total losses. The reason for this is alcohol inhibits your reaction time, and another common sidekick of drinking is speed. And combined, these two potions make for a dangerous cocktail. So let's get back to how your insurance company deals with driving under the influence. It is very rare that clients are arrested and taken for blood tests following a vehicle accident. Well, let me rather say it should be more, but from personal experience, does the number of claims being declined for driving under the influence of alcohol not tested far outweigh the claims declined on the basis of tested. The insurance company's responsibility is to prove, based on the balance of probability, that the incident driver was under the influence of alcohol at the time of the accident. This means that even if you were not tested, but the insurer can prove that you were under the influence of alcohol at the time of the accident, would they have grounds to decline the claim outright? Now, it is not my intention of giving industry secrets, but I will, for the purposes of using an example, explain what would constitute a valid rejection of a claim without blood or a breathalyzer having been administered. The following events are fictitious in nature with the only intent of bringing our point across. Mr. X has a vehicle accident with a third party on Saturday morning at around 3 o'clock. During the investigation, could the assessor prove the insured having consumed 6 draft beers, 2 double brandies and coke, and 3 tequila shots between the time frame of 10 o'clock to 2:30 that morning? How, I will not tell again, but there are many ways in proving that. The assessor furthermore obtained a written statement from an independent witness on the scene that could attest to the sobriety of the incident driving, stating that he was heavily intoxicated, unsteady on his feet, in actual fact fell out of his car and reeked of alcohol. Although there were no police on the scene and the client was not tested, would the above evidence be sufficient for any insurance company to consider declining the claim on the basis of driving under the influence of alcohol? The typical counter-argument received from clients are, yes, I did drink, and maybe too much, but the accident was not as a result of the alcohol consumption. Unfortunately, is this not a plausible argument? If the vehicle was moving and you were behind the steering wheel and involved in an accident, then your state of sobriety is very material to the loss. An unfortunate observation I have personally noticed over the years of investigating driving under the influence of alcohol claims involving fatalities are that in most instances the person walking away from the accident is the intoxicated driver. Reality check to all of us, and yours truly included, is that there is much more at stake than just your claim being declined. Driving your vehicle under the influence of alcohol is against the law, and we will have to see how the new zero tolerance implementation is applied by the insurance industry. I, for one, was never for rejecting a client's claim having consumed a beer or 2 prior to the incident, but these incidents were few and far between. Why? Because people having consumed 2 beers generally don't roll their vehicles 3 o'clock in the morning. It is the individuals that consume copious amounts of alcohol and then decide it is a good idea to get home within 5 minutes 3 o'clock in the morning. I know this is a contentious topic, but our purpose is to share with you the stark realities and consequences of your actions as to ensure we empower you with knowledge, which hopefully leads to better decision makings. Many insurance companies offer products for home drive or Uber, etc. Drinking and driving not only endangers innocent road users, but can see you with a criminal record and a claim being declined. The new zero tolerance will allow your insurer to reject your claim after having consumed a single unit of alcohol. Previously, the law allowed for approximately 2 units of alcohol to be consumed, which was still legal. So many claims had to be paid because the insurer lacked the proof of total units consumed. But with the new law, all the insurer needs to prove is a single unit of alcohol consumption. So the scales of justice has definitely tipped in favor of the insurer. How they will apply this is however to be seen. But we can assure you that the number of rejections for driving under the influence of alcohol will most definitely surge. A fun night out shouldn't put your financial wellness in jeopardy. Don't drink and drive. And if you drink, use home drive or Uber to ensure safety to all the road users.